Hello everyone. In this video, we are going to understand about lease and its types. So let us start from understanding the meaning of lease. Lease is a type of transfer. Lease is a type of transfer of an interest in immovable property. Section 105 of the Transfer of Property Act 1880 defines a lease. So the definition of lease is mentioned in the Transfer of Property Act 1880 under section 105. A lease of immovable property is a transfer of right to enjoy such property made for a certain time, expressed or implied, or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service, or any other thing of value, to be rendered periodically or on specified occasions to the transferor by the transferee, who accepts the transfer on such terms. In simple words, lease means to give any property on rent, in which a person can enjoy the property for a certain time. That is, it could be for 1 year, 3 years, or the time limit which they have agreed in the lease deed. So, lease deed is an agreement between the transferor and transferee. In they are also called as the lessor and lessee. So here, transferor is the person who transfers the property. For example, A owns a building, so he gives it on rent to or lease to B. So here A is called as the lessor or transferor and B is called as lessee or transferee. So in return, a consideration shall be paid. So B shall pay some consideration to A. So it can be in the form of money, a share of crops, service, or any other thing of value to be rendered periodically or on specified occasions. So the consideration shall be paid by B to A on periodically, that is basing on monthly, yearly, half yearly. So it depends on how A and B agrees. So this type of transfer of an interest in immovable property, that is a land or a building. Land could be an agricultural land which could be given on lease for a certain period of time to use and cultivate the land. So which is an immovable property. Such type of transferring an interest is called a lease. So as we have understood the meaning of lease, let us understand the difference between ownership and lease. Ownership and lease. So, in ownership, the owner will have absolute rights and control over the property. But here in lease, the the lessee or transferee will have only limited rights and interest, limited rights and control. The owner shall have the possession of property permanently, and here it is only for a temporary period. We have already understood that a lease will be given for a certain time. So, in ownership, the owner, for example, A is the owner of the property, then he have all the rights over the property. That is the right to sell, right to give it on lease, and to or else gift it, mortgage it, etc. So these are the rights which we already have understood when we learnt about the ownership. So these are the rights which the owner have. But in case of lease, there are only limited rights to the lessee. So this is the main difference between ownership and lease. And the next concept is kinds of leases. The first the first kind of lease is permanent lease. Rights over a property for an indefinite or very long duration, often 99 years or more, and sometimes without a fixed termination date. It is commonly used in land or property transactions. Lessee means the person taking the property on lease, as we have understood before. So, what is meant by a permanent lease? It is a lease, that means transfer of enjoyment of right on an immovable property. So, the period, the extent of such lease could be indefinite, that means no time limit, or without any fixed determination of date. There is no time limit, or it could be for a very long duration. So this kind of lease is called as a permanent lease. So the main features of the permanent kind of lease are no end date. There is no specific end date where the lease will be expired, and it could be for indefinite duration. It could go as long as 99 years, as we have understood here. Often 99 years or more. It could be for an indefinite time. And the next feature is transferability. The rights of that lease could be transferred. For example, A has given B a lease of an immovable property, and B can transfer his rights on that property to someone else, like C. And heritability. Next feature is heritability. That means that if B dies, this property may be given to his legal heirs. So only in this kind of leases, that is permanent lease, all these could be done. In other kinds of leases, this is not available. Next is tenancy at will. A tenancy at will is a rental agreement where either the landlord or tenant can end the tenancy at any time without proper notice, without a specific end date or a written contract. So here, at will means contract. It's a flexible arrangement offering both the parties, that means the lessor and the lessee, freedom to terminate the agreement at their convenience. So, in this type of will, either the lessor or the lessee can break the rental agreement at any point of time with a proper notice. A proper notice should be given by the either the landlord or tenant, and then they can terminate the lease agreement. And the next type of lease is tenancy by sufferance. Tenancy by sufferance. Tenancy by sufferance occurs when a tenant continues to occupy the property even after the lawful tenancy has expired without the landlord's consent, but without being forcibly removed yet. For example, A and B have agreed that the lease will be for a period of 1 year, and 1 year has been expired, and still B have not left the property. So the tenant goes on continue to occupy the property even after the expiry of lease agreement. The landlord or the lessor still did not forcibly remove the tenant. So he continues to stay in the property, though the agreement has been expired. So in this type of circumstance, in this type of tenancy, the tenant shall pay the amount as it is, but the landlord have the right to remove the tenant at any point of time without any notice, because the rental agreement has been completed and the tenant is occupying the property. So the landlord have the right to exclude the tenant at any point of time. So these are the three types of tenancies or leases. So that's all for this class. I hope you all have understood. Thank you.